Welcome back to Making a Murder in My Journal, and today we're going to talk about Zellner's motion that she has filed for stay. And with that, let's get started. And so the defendant applicant, Stephen A. Avery Sr., Mr. Avery, by his undersigned attorneys Kathleen T. Zellner and Stephen G. Richards, moves the court to stay this appeal and remand this cause for hearing on a claim for relief in connection with the state's violation of Wisconsin Statute 968.205 and Youngblood v. Arizona. In support of this motion, Mr. Avery states as follows. Undersigned counsel has uncovered the state's violation of Wisconsin Statute 968.205, where it failed to preserve certain suspect human bone evidence, and number 2, notify Mr. Avery and his attorneys of record of its intent to destroy such evidence. Mr. Avery hereby moves for remand to the circuit court to conduct proceedings consistent with the claim alleged herein. Factual overview. 2. The state's conviction of Mr. Avery was based almost exclusively on forensic evidence. At trial, the state told the jury that all of the incriminating forensic evidence was in close proximity to Mr. Avery's residence. Prosecutor Kenneth Kratz, Mr. Kratz, in his opening statement relied upon several computer-generated scene models, which allegedly illustrated the location of incriminating forensic evidence and its link to Mr. Avery. Mr. Kratz claimed that Mrs. Halbach was murdered and mutilated in Mr. Avery's garage and burn pit. Mr. Kratz attempted to link the following forensic evidence to Mr. Avery because of its proximity to his residence. A. The .22 Marlin Glenfield firearm above Mr. Avery's bed, which was identified as the murder weapon. B. The bullet with Miss Halbach's DNA on it in Mr. Avery's garage, which was allegedly fired from his .22 Marlin Glenfield gun. C. The location of Mrs. Halbach's RAV4 on the Avery salvage yard with Mr. Avery's blood and her blood in it. The human remains detection dog, Brutus, alerted on the RAV4, indicating that a deceased person has been there. D. Mrs. Halbach's electronic devices in Mr. Avery's burn barrel. E. The RAV4 license plate near Mr. Avery's residence. F. The RAV4 key in Mr. Avery's bedroom. 3. Mr. Kratz claimed the proximity of Mr. Avery's burn pit to his residence was particularly incriminating to him. Mr. Kratz specifically told the jury, this particular computer-generated animation is important to embrace or for the jury to look at the case because the burn area is clearly visible. How close it is to Mr. Avery's garage, how close it is to the trailer, how close it is to the other area, what's called the curtilage, that is the area that surrounds Mr. Avery's property, all becomes important. 4. In his closing argument, Mr. Kratz told the jury that the location of the bones in Mr. Avery's burn pit was the most important evidence of Mr. Avery's intentional murder of Miss Halbach. Prosecutor Kratz told the jury the following. We could start with the moment, or with the visual, or with the image of that man, Steve Avery, standing outside of a big bonfire, with flames over the roof, or at least over the garage roof, and the silhouette of Stephen Avery, with the bonfire in the background, and the observation made by some witnesses. And that moment, by the way, although dramatic and although important, should tell the whole story. 5. At Mr. Avery's trial, the trial defense counsel, Jerome Buting, stressed the importance of the bones found in Manitowoc Gravel Pit when he said, if that body was burned somewhere, and then moved and dumped on Mr. Avery's burn pit, then Stephen Avery is not guilty, plain and simple. Now that is why the state has gone to such trouble avoiding the fact that the bones were moved. That's why you heard nothing about it here, because it does not fit with their theory that Avery is guilty. 6. Prosecutor Kratz stated in his rebuttal at trial, these bones in the quarry I'm going to take 20 seconds to talk about because the best anybody can say is that they are possible human. Prosecutor Kratz acknowledged the importance of having the bones identified as human, but he dismissed the defense claim that the bones were human because of the lack of scientific verification for that claim. 7. Prosecutor Kratz told the jury the events at these two locations, Mr. Avery's garage and burn pit, told the whole story, and only one person committed this crime. 8. Therefore, the identification of the Manitowoc County gravel pit bone fragments as Miss Halbach's is material, because it is apparently exculpatory and potentially useful in proving the murder and mutilation did not occur in a location tied exclusively to Mr. Avery. No reasonable trier of fact could conclude that if Mr. Avery murdered and mutilated Miss Halbach in the Manitowoc County gravel pit, he would move her bones from the gravel pit to his own burn pit and thereby incriminate himself. 9. On December 17, 2018, Mr. Avery filed a motion to stay and remand this appeal for scientific testing of several suspected human bones recovered from the Manitowoc County gravel pit. Specifically, Mr. Avery proposed rapid DNA testing that has been successfully used to obtain DNA identification from bones burned to a degree similar to those recovered from the Manitowoc County gravel pit. This testing, argued Mr. Avery, is relevant and material because the identifications of the bones as Miss Halbach's is compelling evidence that her murder and mutilation did not occur in a location connected exclusively to Mr. Avery. Therefore, no reasonable trier of fact could conclude that if Mr. Avery murdered Miss Halbach in the Manitowoc County gravel pit, he would move her bones to his own burn pit, thereby implicating himself. 10. Thus, Mr. Avery argued if the rapid DNA testing identifies Miss Halbach's bones in the Manitowoc County gravel pit, two inferences are reasonable. 1. Mr. Avery is not the murderer, and 2. The bones recovered from Mr. Avery burn pit were planted. There is, therefore, a reasonable probability that such testing would undermine confidence in the jury's verdict. 11. On December 28, 2018, the court denied Mr. Avery's motion, finding that the scope of this appeal is limited to a review of the Circuit Court's orders denying Mr. Avery's Wisconsin Statute 974.06 motions, and that further scientific testing of evidence is not necessary to decide the instant appeal. 12. After filing Mr. Avery's December 17, 2018 motion, undersigned counsel discovered a previously undisclosed police report, September 20, 2011 report. Specifically, a third party provided counsel with a copy of the report. Attached and incorporated as Exhibit A is a copy of the September 20, 2011 report. 13. The September 20, 2011 report reflects the Calumet County Sheriff's Department's transfer of multiple suspected human bones from the Manitowoc County gravel pit to the Whiting Funeral Home for return to Miss Halbach's family. Footnote 2. Defendant does not know whether the Halbach family buried or cremated the suspect human bones. 14. Specifically, the suspected human bones from the Manitowoc Quarry, property tag numbers 7411, 7412, 7414, 7416, and 7419, were returned to the Halbach family according to the September 20, 2011 report. The exhibits attached to Mr. Avery's December 17, 2018 motion describe the location of the suspected human bones in the Manitowoc gravel pit as reflected in Dr. Leslie Eisenberg's report. Group Exhibit 1 to the December 17, 2018 motion. 15. In 2016, Susan Hagopian, Mrs. Hagopian of the Wisconsin State Public Defender's Office, WSPDO, who had been Mr. Avery's prior post-conviction and appellate attorney, provided to undersigned counsel's office entire file pertaining to WSPDO's representation of Mr. Avery. 16. The September 20, 2011 report is not present in undersigned counsel's file kept on this case. 17. On January 3, 2019, undersigned counsel contacted Mrs. Hagopian to request that she confirm whether she had ever seen the September 20, 2011 report. 18. Counsel has obtained an affidavit from Ms. Hagopian. Attached and incorporated herein as Exhibit C is Ms. Hagopian's affidavit. 19. In her affidavit, Ms. Hagopian explains her representation of Mr. Avery began in July 2007 and ended when the Wisconsin Supreme Court denied his petition for review on December 14, 2011. On September 20, 2011, Ms. Hagopian and her co-counsel, Martha Askins, were Mr. Avery's attorneys of record. Ms. Hagopian has no recollection of having seen this police report before undersigned counsel delivered it to her on January 3, 2019. Further, Ms. Hagopian does not recall having a conversation with a representative of the state pertaining to tendering items of evidence from Mr. Avery's criminal case to the family of Ms. Halbach. Moreover, Ms. Hagopian avers that, had she seen this report or had a conversation with the representative of the state regarding the return of the items of evidence to the family of Ms. Halbach, she believes she would recall it. 20. Attorneys Hagopian and Askins filed Mr. Avery's Wisconsin Statute 809.30 post-conviction motion on June 29, 2009. That motion was denied by the Circuit Court on January 25, 2010, and attorneys Hagopian and Askins timely appealed on February 10, 2010. This court affirmed the Circuit Court's order denying relief on August 24, 2011. Then, on September 20, 2011, during the pendency of Mr. Avery's appeal, the Calumet County Sheriff's Department, together with Assistant Attorneys General Thomas Fallon and Norm Gahn, arranged for the return of certain suspected human bones from the Manitowoc County Gravel Pit to the family of Teresa Halbach. On September 22, 2011, attorneys Hagopian and Askins filed their petition for review in the Wisconsin Supreme Court. That petition was denied on December 14, 2011. Now, let's take a moment and read the third footnote. Defendant notes that while state tendered the evidence as issue here to the family of Teresa Halbach, after this court affirmed the Circuit Court's denial and before defendant filed his petition for review in the Wisconsin Supreme Court, his appeal was pending on September 20, 2011. Indeed, pursuant Wisconsin State Statute 808.10, a criminal defendant must file petition for review within 30 days of the Court of Appeals decision. Therefore, defendant's appeal was yet pending on September 20th, 2011, 27 days after the Court of Appeals decision. 21. The state, without notifying Mr. Avery and his attorneys, and during the pendency of Mr. Avery's direct appeal, caused material and potential exculpatory evidence to be transmitted to the Halbach family for its potential destruction by cremation or burial. 22. On January 24, 2019, Underside Counsel received her own copy of the September 20, 2011 report from the Calumet County Sheriff's Office and was able to verify the accuracy of the report provided to Mrs. Hagopian. Roman numeral 2. Because the state violated Wisconsin's preservation of biological evidence statute, Mr. Avery's due process rights were per se violated. His conviction cannot stand. 23. Wisconsin Statute 968.205 governs the preservation of physical evidence collected subject to criminal investigations. Provides. Point 2. Except as provided in subsection 3, if physical evidence that is in the possession of law enforcement agency includes any biological material that was collected in connection with a criminal investigation that resulted in criminal conviction, and the biological material is from a victim of the offense that was subject to a criminal investigation, or may reasonably be used to incriminate or exculpate any person for the offense, the law enforcement agency shall preserve the physical evidence until every person in custody as a result of the conviction has reached his or her discharge date. Section 2M. A law enforcement agency shall retain evidence to which subject applies in an amount and manner sufficient to develop a DA profile as defined in section 939.74 from the biological material contained in or included on the evidence. Subsection 3. Subject to sub 5. A law enforcement agency may destroy evidence that includes biological material before the expiration of the time period specified in subsection 2, if all of the following apply. A. The law enforcement agency sends a notice of its intent to destroy the evidence to all persons who remain in custody as a result of the criminal conviction, and to either the attorney of record or each person in custody of the state public defender. B. No person who is notified under Person A does either of the following within 90 days of the date on which the person received the notice. 1. Files a motion for testing of the evidence under Section 974.07. 2. Submits a written request for retention of the evidence to the law enforcement agency. C. No other provision of federal or state law requires the law enforcement agency to retain the evidence. 24. It is beyond question that the state violated 968.205 when it failed to 1. Preserve the suspected human bone evidence, and 2. Notify Mr. Avery and Ms. Hagopian of its intent to do the same because the suspect bones were biological evidence collected in the course of the state's investigation of Mr. Avery, which ultimately led to his conviction. Additionally, the human bones were, at minimum, suspected of belonging to the victim in the crime of which Mr. Avery was convicted. Therefore, the suspected human bones recovered from the Manitowoc County Gravel Pit are properly considered within the ambit of Section 968.205. 25. Because Section 968.205 does not provide a remedy for convicted persons in the event of a violation, fashioning a remedy is left to the courts, and action Wisconsin courts have yet to take. Footnote 4. As of this motion, there is no published opinion from a Wisconsin court that addresses a violation of Section 968.205. 26. Mr. Avery submits that this court should establish the most just and most logical remedy for such evidence preservation violations, i.e. such violations amount to per se due process violations. This conclusion is borne out of by controlling United States Supreme Court precedent addressing evidence preservation violations. 27. Taken together, Trombetta and Youngblood comprise a line of constitutional jurisprudence that outlines the extent of the state's duty to preserve evidence. In each case, the United States Supreme Court promulgated a test to determine whether the destruction of evidence violates a criminal defense's due process rights. The Trombetta Test focuses on the probative value of destroyed evidence and whether the evidence possessed exculpatory value that was apparent before its destruction. The Youngblood Test, for its part, disregards the probative value of the evidence in favor of examining the governor's role in the circumstances that led to the destruction of the evidence. If a criminal defendant can satisfy either test, then a court will rule the destruction of the evidence was a violation of due process and reverse the defendant's conviction. Youngblood's 48 U.S. at 54. 28. While the U.S. Supreme Court did not clearly state whether the Youngblood Test overruled the Trombetta Test, Wisconsin courts viewed Youngblood as a separate test that complements Trombetta. That is, Wisconsin courts determine whether the Trombetta or Youngblood test apply in a case based upon the perceived exculpatory value of the evidence. 29. In Greenwald, the Wisconsin Court of Appeals set forth this approach to the Youngblood and Trombetta tests after examining the difference between the tests. Because Youngblood added a bad faith determination to the Trombetta materiality inquiry, the Greenwald Court reasoned that the Supreme Court intended to create two complementary preservation of evidence tests. 30. Thus, the Greenwald Court synthesized a two-step analysis to address the destruction of evidence. The outcome of the analysis depended upon two specific examinations. 1. Whether by looking to the facts surrounding the crime itself, the destroyed evidence was apparently exculpatory or potentially useful. And 2. If the evidence is merely potentially useful, did the destruction of the evidence result from the governor's bad faith? 31. Thus, in Wisconsin, the adoption of either Trombetta or Youngblood depends on the probative value of the evidence at issue. ID. If the destroyed evidence is apparently exculpatory, Wisconsin courts will apply the Trombetta test. ID. To evoke Trombetta, a defendant must demonstrate that the government destroyed evidence possessing an apparent exculpatory value. However, to trigger the Youngblood test, all that need to be shown is that the government destroyed potentially useful evidence. Wisconsin courts have followed this line of reasoning. For example, the Court of Appeals stated in State v. Parker, a defendant's due process rights are violated by the destruction of evidence. 1. If the evidence destroyed was apparently exculpatory and of such a nature that the defendant would be unable to obtain comparable evidence by other reasonable means. Or 2. If the evidence was potentially exculpatory and was destroyed in bad faith. 32. While the Trombetta and Youngblood evidence preservation doctrines originally applied only when evidence was destroyed pre-trial, the Wisconsin Court of Appeals stated that Trombetta and Youngblood and Wisconsin's two-part Greenwald test are applicable to the post-conviction destruction of evidence in Parker. There is a long line of cases addressing the pre-trial destruction of evidence and a defendant's due process rights. We see no reason why this line of cases should not apply to a post-conviction challenge to the post-conviction destruction of evidence. 33. Mr. Avery submits that, following Parker, the Griswold two-part analysis should be applied to address the state's violation of the DNA evidence preservation statute in the instant case. 34. When examining the test set forth in Greenwald, Wisconsin courts apply certain presumptions implicit in the DNA preservation statutes. By codifying a right to the preservation and testing as provided in Wisconsin Statute 974.06 of evidence, the DNA preservation statutes create three presumptions regarding both the materiality of the evidence and the circumstances surrounding its destruction or loss. 35. First, the statutes presume that all biological evidence collected in the course of a criminal investigation and covered by the statutes is material. 36. The applicability of either Trombetta or Youngblood depends upon the materiality of the evidence that was lost or destroyed. A hurdle to applying these tests is the impossibility of knowing definitively the material value of evidence that no longer exists. The Supreme Court in Trombetta addressed the difficulty of extrapolating materiality from lost evidence. Courts face the treacherous task of divining the import of materials whose contents are unknown and very often disputed. 37. However, in the context of addressing the materiality of the evidence destroyed in violation of Wisconsin Statute 968.205, this Wisconsin legislature has already resolved that problem, especially when considering together with 974.07, the DNA evidence preservation statute demonstrates the Wisconsin legislature recognition of the importance of post-conviction DNA testing. These statutes taken together provide for the preservation of biological evidence and, in many instances, DNA analysis thereof. The codified right to DNA preservation and testing shows the legislative intent to ensure that DNA testing of biological evidence plays a significant role in the suspect's defense and efforts to obtain post-conviction relief. We have a footnote 5, says see generally Nathan T. Kipp, comment preserving due process violations of Wisconsin DNA evidence preservation statutes as per the violations of the 14th Amendment. 38. Therefore, the Wisconsin legislature, through the DNA preservation statute, placed preserved biological evidence in the class of evidence the Supreme Court deemed material as defined in Trombetta and Youngblood. B. Usefulness of evidence preserved under Wisconsin Statute 968.205. 39. Second, following this presumption of materiality, the DNA evidence preservation statutes further presume that, in every case, biological evidence collected in the course of a criminal investigation is at least potentially useful, as defined in Greenwald. 40. In the context of DNA evidence, apparently exculpatory evidence contemplates instances where results from testing or retesting of biological evidence that excluded the petitioner would exonerate him or her of the crime of conviction. 41. Similarly, potentially useful DNA evidence refers to evidence in cases where, if subjected to DNA testing or retesting, exclusionary results would support the petitioner's claim of innocence. ID at 5. In line with the Supreme Court's reasoning in Youngblood, this category includes evidence that was simply an avenue of investigation that might have led in any number of directions, and the evidence about which no more can be said than that it could have been subjected to tests, the results of which might have exonerated the defendant. 42. These categorical requirements for potential useful evidence necessarily apply to biological evidence covered by the DNA Evidence Preservation Statute, because preserved evidence test results allow reasonable persons to disagree as to whether the results of the DNA testing rule out the possibility of guilt or raise a reasonable doubt of guilt. 43. Therefore, evidence covered under the Biological Evidence Preservation Statute must be deemed at least potentially useful, and the destruction of such evidence triggers, at minimum, the Youngblood due process analysis. C. The DNA Evidence Preservation Statute presumes that every violation thereof constitutes bad faith. 44. Lastly, because the statutes prescribe the normal course of conduct for Wisconsin law enforcement agencies regarding the collection, preservation, and eventually destruction of biological evidence, every violation of the statute constitutes bad faith as defined by Youngblood and Greenwood. 45. The Youngblood Court reasoned that law enforcement actions suggesting bad faith arise when the police themselves, by their conduct, indicated that the evidence could form a basis for exonerating the defendant. This consideration, in turn, hinges on the police's knowledge of the exploratory value of the evidence at the time it was lost or destroyed. In these cases, bad faith exists when the conduct of the police is outside the scope of normal practice. 46. The Youngblood Court's definition of bad faith takes for granted that there are times when the police will not know whether evidence was material before its destruction. The DNA Preservation Statute eliminates this assumption by creating an affirmative duty to preserve all biological evidence taken from the crime scene. Thus, law enforcement agencies are on notice that biological evidence is deemed important to the successful administration of criminal justice, and therefore may not claim ignorance that the destroyed evidence was at least potentially useful. 47. Wisconsin Statute 968.205 imposes certain duties upon law enforcement agencies. At the most basic level, the state bears a duty to preserve all biological evidence collected during the course of an investigation that leads to a conviction. Additionally, the statute sets forth the steps that the state must take before lawfully destroying any evidence in its possession. Because of a violation of the DNA Preservation Statute means the state did not abide by either the requirements for preservation or the proper destruction of the evidence as prescribed by law, such conduct indicates bad faith. 48. A violation of DNA Preservation Statute constitutes bad faith. This conclusion is not undermined by the Wisconsin Court of Appeals' adoption of the official animus standard in Greenwald. The Greenwald Court emphasized that bad faith does not exist when the destruction of evidence was due to inadvertent or negligent actions on the part of law enforcement. However, this exclusion only pertains to two situations where evidence preservation was 1. Required by uncodified law enforcement agency policy, or 2. Not required by any policy. ID. Mr. Avery submits that a violation of state law goes far beyond the negligence standard that the official animus framework was formulated to replace. That is, a violation of state law should not be analyzed within the context of mere negligence or inadvertence. Indeed, such a violation should immediately trigger official animus, as adopted in Greenwald, as per C showing of bad faith under Youngblood. 49. Additionally, the state acted in bad faith where it was on notice that the trial court had ordered preservation of certain items of DNA evidence, yet proceeded to effectuate the loss of biological evidence within its control. On April 4, 2007, the trial court entered an order for the preservation of blood evidence and independent defense testing. This order contemplates and allows future DNA testing by Mr. Avery. In its order, the trial court gave Mr. Avery the opportunity to, at any time, submit items of evidence for DNA testing. 50. It is clear that the parties have broadly construed the scope of the April 2007 order to permit testing of a variety of biological samples deemed relevant in the instant case. The state was on notice of this agreement in September 2011 when it facilitated the destruction of suspected human bones recovered in the Manitowoc County gravel pit. 51. That the state knew it bore a duty to preserve biological material at the time it facilitated the potential destruction of the suspected human bones without notifying Mr. Avery and his attorneys. The state, by taking these actions, acted in bad faith and with official amnesty as defined by Youngblood and Greenwald. Find in bad faith where government actors destroyed potentially exculpatory evidence when they were on notice that the evidence at issue should be preserved. Find in bad faith where law enforcement agents destroyed evidence they knew the defendants asked to preserve. Subsection D, Application 52. The presumptions created by the DNA Evidence Preservation Statute shape the analysis that Wisconsin courts should undertake when confronted with instances, such as in the instant case where a law enforcement agency violated the statute. This analysis is grounded in the two-part test set forth in Greenwald. However, it differs to the extent Wisconsin court apply the presumptions created by the DNA Evidence Preservation Statute. These presumptions, as set forth above, dictate issues at the heart of the test. 53. As described more fully above, the first step in the Greenwald analysis is an inquiry into the first two steps of the Trombetta Test, whether the destroyed evidence was apparently exculpatory. The examination asks whether, if the destroyed evidence was subjected to testing or retesting, favorable results would exonerate the petitioner, and whether the state was on notice of this fact. If the state failed to preserve evidence that was apparently exculpatory, and if the state was aware of its exculpatory nature, then the court must vacate the conviction. If, however, the evidence is not deemed apparently exculpatory, then Wisconsin courts should apply the Youngblood test under the second step of the Greenwald analysis. 54. Under the Youngblood test, courts would examine whether the evidence was potentially useful, and if so, whether the police acted in bad faith when they destroyed the evidence, i.d., in light of the presumptions created by the DNA Evidence Preservation Statutes described fully above, the evidence must be considered potentially useful. Next, the court considers whether the law enforcement agency acted in bad faith. As set forth above, the presence of bad faith is presumed every time the DNA Evidence Preservation Statute is violated, because such a violation means that a law enforcement agency acted outside the scope of its normal practice by destroying evidence it knew had to be preserved in compliance with Wisconsin law. 55. In the instant case, the suspect human bones are potentially useful, meaning that retesting of the suspect human bones from the Manitowoc County gravel pit could demonstrate Mr. Avery's alleged actual innocence. It is indisputable that the state violated the DNA Evidence Preservation Statute by returning the suspected human bones to the Halbach family. Mr. Avery's due process rights under Youngblood had been violated. 56. According to federal and state due process jurisprudence regarding the state's duty to preserve evidence, the appropriate remedy for a violation of Wisconsin DNA Evidence Preservation Statutes is the reversal of the criminal defendant's conviction. Therefore, the case should be remanded to the circuit court to conduct proceedings to determine if there has been a due process violation and how that violation should be remedied. 57. Mr. Avery has brought this issue to the court's attention in a timely manner. He does not want to waive this issue by not addressing it at this time. The appeal must be stayed and this issue must be remanded to the circuit court for proceedings that should include a hearing in which Deputy Jeremy Hawkins, Sergeant Investigator Mark Wiegert, Attorney Thomas Fallon, and Attorney Norm Gahn would be subjected to cross-examination concerning the illegal transmission without notice to Mr. Avery's prior counsel and the presumed destruction of the Manitowoc County gravel pit suspected human bones. The undisclosed September 20th, 2011 report contradicts Mr. Kratz's representation to the jury that these bones in the quarry I'm going to take 20 seconds to talk about because the best anybody can say is they are possible human. The state, by its actions, has implicitly admitted that the bones are not only human, but they belong to Miss Halbach. The state cannot credibly argue that it returned animal bones to the Halbach family for burial or cremation. The state's actions demand that further proceedings be conducted to determine if Mr. Avery's due process rights have been violated and if the state acted in bad faith in returning the suspected human bones to the Halbach family. Part 3. Conclusion. Wherefore, undersigned counsel respectfully requests that the court enter an order staying this appeal and remanding the case to the circuit court for proceedings to determine whether the state has violated Wisconsin Statute 968.205 and Youngblood v. Arizona, dated this 24th day of January 2019, respectfully submitted, Kathleen T. Zellner, and also signed by Stephen G. Richards. So that was a lot of reading, but what we figured out is that this motion, she is following this to the T. So what has happened is Wisconsin has a statute that states that they will preserve the biological evidence in a case until the people that are being accused or found guilty of a crime connected to the biological material is no longer in custody. And in the event that it is destroyed, there are 2 previous cases, actually 3, which are pre-trial. So this is the complication, is that Zellner is facing post-trial, post-conviction. So what we're looking at is she's actually wanting to bring the individuals that released this the bones back to the Halbach family up on criminal investigation and then see where we go from there. Now, she is also stating that Ken Kratz, the state prosecutor, had made claims to the jury that he wasn't going to spend more than 20 seconds on those bones because they were possible human. However, it undermines the story that the state has given the jury. It undermines the conviction of the jury when the bones are returned to the Halbachs, because it is stating in that action that those bones not only were human, but they were Teresa Halbach's. And that could have very well changed the entire conviction or the entire trial. If the bones are actually Halbach's and they're in a gravel pit somewhere besides Stephen Avery's, it doesn't only direct this entire trial as him the only suspect. In other words, we may not have had the Denny law. So this is a big deal, and we're going to have to follow this really close. I'm sorry if it sounded a little boring, but you need to be able to understand this case from the legal aspect as well, and I don't want to misquote, and so that's why I give you that. So thank you so much for joining me. If you are interested in this case and you want to follow, please go ahead and hit the subscribe button. If you enjoyed the video itself, hit that like button. If you want to be notified when I release a video, you can always hit that little bell. So I thank you for watching, and that's what we have for now on the Zellner update and why she filed a motion for stay, which I'm all for it, because yeah, if they gave those bones back to the Halbachs, well, they were Teresa's. So with that, let's go ahead and close this out, and if you didn't do the crime, you shouldn't set the time. Thank you for watching. Bye for now.